This isn't just about the Sims 4 game. If you play any game in the EA, I'm going to show you the exact games within EA that there is now a class action lawsuit that on February 3rd, 2026, they want you to sign a new waiver with Sims 4 to be able to play the Sims 4. I uninstalled the EA app because of a patch that was coming on February 3rd. Well, it just so happened with this broken patch that they issued, there was a new specific agreement that placed even more restrictions on the ability to sue, and specifically a waiver for a class action. So this is very important information, and I hope that people will consider sharing what I'm about to share with you, because this is information that everybody needs to know. So I talked about this whole Sims mess and so forth, but then I got into this information that I didn't know about, that of this class action and this new waiver that they're wanting to me. I am so glad that I uninstalled this app on February 2nd before they dropped this new agreement, because honestly, myself, like a lot of people, they just sign the agreement just so they can have access to the game, right? Well, if you've uninstalled this app waiting out this mess from the update, do not reinstall. And here's why. I mean, you can if it doesn't matter to you, but I'm just saying, this is what you can do. I'm going to share the addresses and the specific countries that there is some lawsuits and ability complaints against Sims to get refunds. Okay, so there have been some specific complaints about Sims and so forth. I said, this is what EA did. They sold data on their players to Facebook. Okay, and I've recently shared that I randomly got a check in the mail on some class action from back in 2022 from Facebook. Like, they're constantly violating our privacy rights. It never ends, right? I recently shared, you can go through my recent videos. I think it was a short video that I shared of getting a check from Facebook on a class action I didn't even know about. This time I know about this one and I'm taking action because I'm just fed up with Facebook. Like, they're now, EA is selling our data to Facebook. Okay, so this is what happened. EA sold data on the players to Facebook, and there's a class action. Okay, and on February 3rd, yes, they had people sign a new waiver with the update on Sims 4, waiving their right to this new class action. So this is Google Gemini explaining what's going on in this situation. It said there is an active legal investigation regarding EA sharing user data with Facebook. And the February 3rd update came with significant changes to the legal agreements that you must accept to play. So the Facebook data investigation, law firms, and I'll share which law firms that you can contact. I'll put all the links in the description once this live stream is no longer live, and you can do whatever it is you want to do. So law firms are investigating claims that EA used a metapixel, which is a tracking tool, including our offline activity. These people are disgusting. They put a tracking tool in a metapixel to secretly share your video game purchase history with Facebook without your consent. And not only that, they're forcing us to continue, after people have spent decades investing in these games, in order to continue to use your investment, now they're forcing you to sign an agreement that you have to surrender your rights to AI. Okay, so I'm just saying, it's time to get an attorney, right? And there's attorneys already on this. So this is what they did. They secretly sharing your video game purchase history with Facebook without your consent. This is unlawful what they're doing. The violation potentially violates what's called the Video Protection Act, the VPPA, which is a law in the U.S., and I'm going to go into the other countries' laws that's also being violated. So if you live in Canada, the UK, Australia, and the EU, what you can do and how. It was a law designed to keep your viewing and rental history private, and they violated it. So who qualifies? Typically, these claims apply to users in the US who have an EA app account and purchased a PC game from the site within the last 2 years. So how do you join? Many of these cases are currently in the mass arbitration phase rather than a standard class action. You can check your eligibility or sign up for investigations through platforms like Lantern by Labaton or ClassAction.org. The potential award. Some firms suggest eligible users could be entitled up to $2,500, though there's no guarantees. The February 3rd new terms. When you updated your game, which I did not on February 3rd, but for those who did, you were prompted to agree to a new user agreement. The key restrictive highlights include mandatory arbitration and class action waiver. So if you've not reinstalled it, don't. You need to immediately send a letter of opting out, and I'll share that with you. Okay? This is the big one. By agreeing, you give up your right to sue EA in a traditional court or join a class action. So instead, you're forced into private arbitration. You can't even join mass arbitration. This is where the new terms have come in because they've been using these arbitration clauses for quite some time, right? But they've put more restrictive terms on it, so you can't even join mass arbitration. So don't sign it. I'm not. So it's faster, but it's harder for consumers to win. So they're also including license not owned. The terms explicitly state that games are licensed to you, not sold. The EA reserves the right to remove access to content or reset the game parameters, like your saves or family tree. So basically, they're wanting, this is what they did, and they're so sneaky the way they went about it. So the EA Sims warned people that there could be damages to your saves or your family trees if you use mods. But if you're a veteran player, you already know that a lot of times they're always blaming mods for all the bugs that they have going on. So the vanilla players are basically people who do not use mods. There's many players saying, nah, you cannot blame mods on these bugs because we're vanilla players. And they group together and say, nope, we're vanilla players. We don't use mods. And we're having the same issue. This is not a mod thing. So ahead of time, before they did the February 3rd update, they were saying, warning that you're going to have you could have these damages to your family trees, etc., etc. Okay, and then on February 3rd, they just slip in this little agreement that you have to sign that they can basically destroy your game and you don't have a right to hold them accountable. Well, no, don't sign it. But I'm just telling you what they're up to. And of course, people who are EA sponsored are not going to share this information with you on these big YouTube channels while they're pushing these new packs, hurrying up and getting the masses to sign this new agreement, not telling anybody anything about this. So it's saying the EA is reserving this right to remove access to content, or that they can just completely destroy your game. They can reset the perimeters like your saves or your family trees and not be held accountable after you've spent years building your legacy files. Okay? If they deem it necessary for technical limitations or balancing, just say no, guys. Now, not only that, in addition to that, they're demanding that you surrender your rights by giving up for AI training rights. There's newer clauses that allows EA to analyze your user-generated content, meaning your builds, like your gallery builds or your sim descriptions, to improve their services or train ML AI models. So basically, if you're having to give up your right after 10 years of investing into their product, now in order to continue to use that product, you have to surrender your rights. Well, no, you don't. That's something that you can take to court. Data collection even offline. This is so problematic. They've clarified that they track your activity even when you're playing offline. That is not okay, people. This data is uploaded the next time you connect to the internet. So this, now keep in mind, this isn't just about Sims. This is a lot of games through EA, and I'm going to go into the list of those here in just a minute, okay? Hello, Angie. So the next steps, if you want to keep your right to sue in court or look for an opt-out clause in the EA user agreement, you usually have to send a physical letter to their headquarters within 30 days. So within 30 days of February 3rd, which is their new restrictive terms that they put in their agreement, of first agreeing to the terms to legally opt out of the arbitration requirement. So this is exactly why my staying away from the app right now is such a power move. By uninstalling, which I did uninstall on February 2nd because I said no to their damages that they were going to do to my save files, it said you have not signed those new February 3rd terms yet, keeping your legal options open while everyone else clicked agree just to get their save files. So the EA user agreement is designed to protect the company, but consumer protection laws in places like the UK, EU, and Australia are designed to protect consumers. So here's the top things to tell other Simmers if you share this. The 30-day window. Remind them that if they did update, they have 30 days to send a physical opt-out letter to EA, and I recommend sending it return receipt certified, to keep their right to sue in court rather than private arbitration. Proof of purchase. Tell them to save their email receipts for every pack they bought. If a pack like high school years or university is broken, like the black photo bug, those receipts are their evidence for a Consumer Rights Act refund. Because there are some countries, and I've asked about that, there are people who are actually getting refunds from EA. They don't tell you this, but people like in Canada and UK, Australia, they're actually getting refunds when they, cause photo damage and stuff like that. They're actually getting refunds. Sadly, their laws are better than ours in the US. But just so you know, the Metapixel case, anyone in the US who bought games through the EA website should look into the VPPA investigation to see if their data was shared with Facebook. Back up everything before any future update. Copy the electronics folder to a USB drive. If EA fixes, wipe your builds again. They cannot claim you lost the data if you have an external copy. Okay? So you've basically turned your update strike into a legal shield for your data. If you want, I can help you find the exact. So here's the email addresses. So to protect your builds and your legal rights, you can formally opt out of EA's mandatory arbitration and request refunds for broken content like the photo bug. Below are the specific addresses and steps for your region. This is for people in these countries I'm about to show you. Opt out of mandatory arbitration. For US, where to mail your notice in the USA, Canada, and Japan. By sending a physical letter within 30 days of agreeing to the new terms, which you haven't yet, to keep your right to join the class action lawsuit or sue in a traditional court. And I will copy and paste these in the description once this video is no longer live. And of course, this is exactly what you say. So for the UK, the EU, Australia, and the rest of the world, you would mail stuff to here. And so what to include is your full name, your EA account username, and a clear statement. And I will copy and paste this. I am formally opting out of the arbitration agreement class action waiver in the EA user agreement as of today. And make sure you do it within 30 days of February 3rd. Requesting refunds for broken content. If the photo bug or the stair glitches make a pack unfit for purpose, use these official channels to bypass the standard no refund bots. In Australia, the ACCC enforcement, EA must honor the Australian consumer law, which says consumer guarantees do not expire just because you downloaded the game. And this is the phone number. This is the direct email, okay, to make your claim. United Kingdom Consumer Rights Acts. Under the CRA 2015, you are entitled to a repair or a replacement. If they cannot fix the photo bug or the stair bugs, you can demand a price reduction or refund. Drafting tip. Mention the citizens' advice guidance. The digital content is not of satisfactory quality or fit for purpose under the Consumer Rights Act 2015 due to online game breaking bugs. The privacy complaint Metapixel. If you're in the United States and you purchased games On the EA website, you may be eligible to join the investigation regarding your purchase history being shared with Facebook. Okay. Where to check? You will visit this site. I'll put the link in the description. Lantern by Labaton or similar firms that are investigating the VPPA violations. This is American law that they have violated, that they're investigating. The process for opting out of mandatory arbitration or requesting a refund will vary depending on your region and the specific issue that you're addressing. The details provided above should guide you in taking the appropriate next steps for your situation. So I said, how many games in EA sold data to the Facebook? Is it just The Sims? It's not just The Sims. The investigation to data sharing via the Metapixel covers a massive chunk of EA's PC catalog. So what games are involved? Attorneys are investigating claims that the EA secretly shared purchase information with Facebook for any video game containing cutscenes. So this is because a federal court ruled that these cinematic scenes qualify as video content under the Video Privacy Protection Act. According to legal filings, the list of games that could qualify for a claim includes the Sims franchise, including Sims 4 and potentially other Sims. EA Sports titles, the EA Sports FC, formerly FIFA, Madden NFL, NHL, PGA Tour, UFC, and F1. The action RPG titles, Apex Legends, Star Wars Jedi Survivor, Mass Effect series, Dead Space, Wild Hearts, and Immortals of Avium. Racing Other, Need for Speed Unbound, Battlefield 2042, and Super Mega Baseball. How to join the suit. Since the cases are primarily being handled through individual arbitration due to these pesky terms of service you've avoided, you don't typically wait for a class action check. Instead, you sign up with a law firm that handles the case for you. So who is eligible? Generally, you must live in the U.S., have an EA account, purchase a PC game from them within the last 2 years. So you'll sign up by Lantern by Labaton and currently taking names of affected players to seek up to $2,500 per incident. Per incident. So I don't know if that means if you bought multiple games from EA, then there may be even more than this amount here. So again, this is not guaranteed, but it is potentially seeking up to $2,500 per incident. So in the new terms, the February 3 update, since you've not reinstalled the app, you are in the clear for now. However, the updated EA user agreement pushed this month strengthens their mandatory arbitration and class action waiver. So that means once you click agree, you lose the ability to join a standard class action, and you must use their private system to settle disputes. So if you plan on sharing this with friends, remind them to save their EA.com order confirmation emails. Those are the receipts needed. Of course, you know, if you don't have that, you can just get the statement from your bank that, will show where you made a purchase if you use like debit card online or whatever. So those are the receipts needed to prove they bought a qualifying game while the Metapixel was tracking them. So, would you like to check if there's similar privacy lawsuits? So here's what the change is. The concept of arbitration in EA is not new, but they have added a latest update, February 3rd, adding the mass arbitration protections for EA. So this anti-mass clause is in response. And the fact that there's an active class current action, and they're not telling you that there is, while they're trying to get you to sign waivers, you take action against that also. So in response to recent law firms filing thousands of individual arbitration cases at once, which cost EA millions in filing fees, the new terms include a grouped arbitration section. The 60-day lock. You are now forced into an informal dispute resolution process for at least 60 days before you can even file for arbitration. But I didn't sign anything on February 3rd because I uninstalled the app on February 2nd because I just said no. So arbitrator shift, they have updated their designated arbitration provider. moving to groups like the National Arbitration and Mediation, which some consumer advocates argue are less friendly to individual players. So why this February 3rd date matters? Because if you uninstalled the app like I did, then you are in a unique position. You have not reassented. So every time EA updates these terms, they require a fresh click to agree. By not reinstalling, you have not technically agreed to this 2026 version of the waiver, which is much more restrictive regarding how many people can join a claim together. So while you've got these YouTube EA sponsored channels pushing this new pack and encouraging people to play this game, they're not saying a word about the fact that the more people sign it instead of opting out, it helps them because it's restrictive regarding how many people can join a claim together, right? So the opt-out refresh, even if you agreed back in 2014 or 2022, a major update to the terms usually resets the 30-day window to opt out via a physical letter. So the bottom line, EA's been trying to block lawsuit for years, but they just patched their legal code on February 3rd to make it even harder for players to band together. So if you decide to come back, here's the exact wording that you should include in your opt-out letter to make sure that it's legally binding. And here it is. So I'll copy and paste this. Okay. To legally opt out and keep your right to sue in court, here's what you should send in a physical letter. And then, of course, contact those links, those firms that's handling the investigation and so forth. This is basically it right here. And where to send it is right here. Proof of delivery, just like I said, return receipt certified. Okay? And or registered post in the UK, Australia, and EU. This gives you a tracking number and a signature proving that they received it. And if they claim you never opted out, this receipt is your get out of jail free card. The 30-day clock, this clock only starts the first time you open the EA app and click agree to the new February update. Since you haven't reinstalled yet, your 30 days has not even begun. So keep a copy, take a photo or scan of the signed letter and your postal receipt before you drop it in the mail. Okay? So there you go. And you don't have to worry about them attacking your account either if you do this, because I've covered that also. It says they cannot cancel your account or mess with your library just for opting out of arbitration. The EA user agreement is designed to allow the specific opt-out choice without punishing you or removing your access to the game. So you don't have to worry about that. But anyways, that's it for this one. I don't want this to be a long video. I just wanted to share this information for people who play games via the EA app. Please share this information.